Well,
Michael and Olu, we've started.
okay.
There's
Thank
feedback
you
on
very
this.
much. Hello, everyone. Good morning. Thank you for joining us for this workshop on Introduction to the Communications Procedure for the African Commission on Human and People's Rights. My name is Oludayo Fagbemi. Most people call me Dayo. And I'm a senior legal officer at the Institute for Human Rights and Development in Africa. And facilitating this session today will be my colleague from the Center for Human Rights, University of Pretoria, Michael Nyarko, who is the Manager, Litigation and Implementation at the Center. I don't know if Michael is ready. We have, I think, 10 participants now. Should we go on or try to wait for a few minutes to see if more people will join us?
I mean, I would give it a few minutes to see if we would have a bit more participants. Let's say 5 minutes past, and then we can.
5 minutes past.
Yeah, we can just proceed if we have a bit more. Oh, whether or not we have a bit more, let's start 5 minutes past.
Yeah. All right. Thank you, Michael. So, participants, please exercise patience with us. Let's give it about 3 minutes more to see if we have. Thank you.
For some reason, I still hear the echo from you. I don't know if Tiffany has the same experience as I have.
It's sometimes me.
Do you get an echo from Oludayo?
Perhaps I should discard the headphones and just look at it. Can you still hear me clearly and without the echo?
It's actually better now, at least on my side.
Okay, great. Okay, we'll proceed like this then.
Olu and Michael, can you see when people raise their hands?
Well, I am not so familiar with go-to meetings, so I.
Okay. Because I think it would help me know when people raise their hands. Do I have to let you know, or can you already see that and note them for when they have questions? So, for example, I saw Vivian had raised her hand and Dennis. Vivian's raised her hand.
hands up.
I think what I'll have to notify you of when hands are raised.
Okay.
Thanks.
Okay. All right, Michael, shall we start now? It's 5 minutes past 10. We have about 14 people with us.
Yeah, I think we can start that.
Okay, great. Once again, thank you everyone for joining us in this workshop on Introduction to the Communications Procedure of the African Commission on Human and People's Rights. Like I said earlier, my colleague Michael Nyarko from the Center for Human Rights will take us through the presentation. And yes, it's ready. Michael, you have to.
Yes, thank you very much, Dayo, and good morning. Well, good morning, good afternoon. I suppose we are on very different time zones right now. So greetings to everyone, one of our participants, and welcome to today's presentation on the rules of procedure of the African Commission. I will be focusing on the communications mandate, but especially how the 2020 rules of procedure that was recently adopted affects or perhaps impacts the communications procedure. And I suppose a lot of us are already familiar with the Commission's composition and workings, so I shall not bother you with, if you like, introductions to the Commission itself. I will assume that these are things that are already familiar to you, unless there are any specific interests. But otherwise, as we all know, the Commission has a two-pronged mandate that is imposed on it by the African Charter, the promotional mandate and the protection mandate. And one of the means through which the Commission performs that protection mandate is through the communications procedure. In terms of the Charter, there are two main forms of communication. The interstate communication, well, I suppose there are three of them. There would be the interstate communication, there would be the other communication, the so-called other communications, which the Commission has interpreted to mean individual communications and communications by CSOs. And then there is the what do you call it, the advisory opinion mandate, which is also to some extent, a part of the communications procedure of the African Commission. For today, we will be focusing on specifically the so-called other communications, which is the communications brought by individuals and civil society organizations, whether as victims in their own rights or as CSOs who are representing the interests of victims. I do have slides that I can share with the participants subsequently. I have intentionally I'm intentionally not sharing my screen right now because I want us all to be as participative as possible. And sometimes when the slides are on the screen, we read and we stop listening to the conversation. So I'm happy to share the slides subsequently if there is interest from among the participants. But otherwise, I will just jump into the individual complaints procedure as currently pertains under the African Commission's Rules of Procedure of 2020. So as of now, the rules require that if you're submitting a communication, that communication should be submitted in one of or any of the working languages of the African Union, which, according to Article 11 of the Protocol amending the Constitutive Act of the African Union, includes Arabic, English, French, Portuguese, Spanish, Kiswahili, and any other African language. So it is a bit contentious whether you could essentially submit a communication in any language at all, or whether the African Union makes specific pronouncements every now and then on what is the expansion on the specific list that is provided in the protocol. But I would assume that the communication must be in at least one of these 6 or so languages, and that if you would want to write the communication in a different language, it might be useful to seek clarification from the Secretariat if they have the capacity to deal with the communication in that language. But in terms of how the Commission determines whether or not the communication that you have submitted complies with the requirements for seizure, perhaps I should mention that one of the important changes that the new rules of procedure has brought is the fact that now the seizure decision is taken by the Secretariat and does not require the Commission as a whole to have a meeting to decide on the seizure. So the Secretary would have to examine the communication that you have submitted and ascertain that you have included the particulars of the complainant, including the signature. So if the civil society organization is the complainant, then whoever is the legal representative of that civil society organization must sign the communication as well. If it's an individual, I'm receiving a request to share my webcam. I'm not sure if Dayo, can you confirm if you can see me?
No, we can't see you right.
Can you see me now?
Yes, we can see you now.
Okay, now my apologies. I don't know what happened to the webcam. So in terms of the particulars, as I was mentioning, you must include the particulars of the complainant. So if it's an individual complainant, you must provide who this individual is, the date of birth, the country of origin, and stuff like that. And that the complaint must be signed by, if it's an individual complainant, that individual. If it's a CSO that is submitting the complaint, it must be signed by the person who is duly authorized as the legal representative of the CSO. It does not need to be the lawyers who are filing the case. For instance, the CEO or the designated officer of the organization that is representing it before the Commission must sign it. It doesn't have to be signed by a lawyer per se. And that the communication must also include a statement on anonymity. So when you submit a complaint, you must indicate to the Commission whether or not you wish to have your identity to be withheld. So in terms of your communication to the Commission, you must actually indicate who you are and where you're from. But as between the Commission's communication with the state, you can request that the Commission does not share your identity with the state if you have certain fears, especially that you think that this might be dangerous, you might face reprisals or some other form of, if you like, disadvantaged by your identity being known to the state party. You can request that your identity be withheld from the state party. But you must also include the address for correspondence, the physical address, email, telephone numbers, of which you can also request the Commission not to disclose to the state party. Of course, it would be quite useless if the state does not know your name, but they know your address or your email or telephone number. That would actually make it easier for them to find you. So you would have to disclose these things to the secretary or the secretariat, because they would have to communicate with you in terms of what the response of the state is and the Commission's own procedures throughout the process of the communication. And then the complaint must also include a factual background. So the exact factual circumstances that is the reason for the complaint, including, if possible, the name of the victims where the victim is not a complainant. And the commission also requires now that you must provide proof that the victim consents to the complaint being filed on your behalf. That if you are unable to provide proof of consent, you must then write a justification as to why you could not obtain such proof, or why such proof cannot be required. I mean, I can foresee, for instance, if someone is being held in detention and not being granted access to family or counsel, that would be a good reason, for instance, to indicate to the commission that you are unable to secure the consent of the individual because they are not available to you. Or if there are, mass human rights violations which involve a lot of victims, it would perhaps be impractical to require that you obtain consent of every single potential victim before you can submit a complaint to the commission. So I mean, these are not exhaustive list, but I'm just indicating some of the circumstances for which I would assume that the consent of the individual's consent will not be required. But you must also indicate the state party against which this complaint is being filed. Of course, we all know that the duty bearer for human rights violations, especially before international human rights mechanisms, is the state bearer. So that even if the perpetrator of the rights violations is an individual or a non-state actor, you would have to file a complaint against a specific state, which is a party to the African Charter or the other relevant human rights instruments which the state has ratified. I suppose I must clarify here that, I mean, unlike the African court, the African Commission does not have as wide a jurisdiction when it comes to the kind of instruments that can be subject to complaints before the commission. And in addition to the African Charter, there are two specific protocols that also grants the commission the power to receive complaints and to analyze case reports in that regard, namely the protocol on the rights of older persons and the protocol on the rights of persons with disabilities. So that if there's a state party which has ratified either of these protocols, you can, in addition to the African Charter, make claims for violations of either of those two protocols. And as I indicated earlier, the seizure decision is now administrative. So it's the secretary who must, within 60 days of receiving the communication, indicate to the applicant whether or not the commission has accepted the communication or has seized itself of the communication. And that is deemed to have completed that first stage of the complaints procedure. In instances where the secretary rejects or declines seizure of the complaint, the commission may still overturn that decision of the secretary by a majority, or as the rules of procedure says, by an absolute majority of the members of the commission. So if you receive a decline from the secretary, that does not in itself mean that that's the end of the case. You can still make some representations to the commission on why it should seize itself of a particular communication. But I mean, in terms of the rules, there is a requirement for the secretary to report to the commission on which cases it has made decisions on seizure and the reasons why some cases have been declined. The commission may, on its own, decide to review some of the decline decisions of the secretary. One of the changes that has also been occasioned by the rules of procedure is, previously you had to make submissions on seizure, and then if the commission makes a determination on seizure, then you make submissions on admissibility. And then when there's a determination that is made on admissibility, now you make submissions on merit. In terms of the 2020 rules, parties are now required to make joint submissions on admissibility and merits together. So within 60 days of being notified by the secretary of the commission having seized itself of the communication, the applicant must file its submissions both on admissibility and merit. And I suppose one of the reasons perhaps why the Commission now wants a combined submission of both admissibility and merits is to perhaps shorten the time frame within which these back and forth filings of briefs sometimes take so long that it unduly prolongs the process before the Commission. So just remember, if you're filing a communication now, you're required to file both admissibility and merit, and you're not on that three-stage approach that used to persist under the old rules of procedure. And now the rules also require that the pleadings of the applicant must be transmitted to the state party within 14 days, and that the state party must respond within 60 days of receiving the applicant's submissions. So they are streamlining the kind of time frame within which this communication must proceed within the Commission. And if the applicant decides to provide a reply to the respondent state's submissions, they must do that within 30 days. So there are quite strict timelines within which the parties must make submissions. And in exceptional instances, the Commission may request the parties to make supplementary submissions where it requires some other form of information that is not provided by either the applicant or the respondent. And then within 30 days of receiving the Commission's, if you like, decision on seizure, or receiving the Secretary's decision of the case being seized, and being requested to make submissions on admissibility and merit, the party who seeks to make preliminary objections must raise those objections within 30 days, so that if the applicant, well, perhaps in most instances it is the respondent state that does make this kind of preliminary objections, but the state party has 30 days within which to raise those objections. And if those objections are not made within those 30 days, then it will have to seek leave from the Commission to actually raise objections beyond this time period stipulated. But I suppose for the applicant, one of the objections that could be raised is if a particular commissioner has a personal interest in the case, has dealt with the case previously in a different capacity, or is interested politically or in some other way in the outcome of the case. That's one of the issues that an applicant, for instance, can bring to the attention of the Commission in terms of preliminary issues. The rules also now indicate that the Commission may join a number of cases if they are against the same state, emanate from the same set of facts, or they allege similar violations. So it does not actually need to have been filed by the same applicants. If a number of cases have been filed against the same state and they seem to relate to the same set of facts and allege the same violations, the Commission may join these cases and consider them to be the same case and treat them as such. In terms of timelines, if the party is out of time and would like to seek extension, that is allowed under the rules, but note that you would not get an extension beyond 30 days. So if you seek for an extension, the maximum that the Commission can grant you is 30 days. I suppose you might be able to seek a further extension of 30 days, but in terms of the rules, the Commission is only allowed to grant an extension of not more than 30 days. I will quickly move on to the admissibility requirements, which of course are the same as listed in Article 56 of the African Charter, namely that the name of the author must be indicated. You must also show that the communication is compatible with the African Union Constitutive Act and the African Charter, and that you must not have written the communication in insulting or disparaging language. And this has sometimes been contentious between state parties and applicants. There are a number of cases, particularly before the African Court, for instance, where a state party has raised objection on the basis of disparaging language because the party, for instance, says that there were human rights violations in the state party concerned, or that the courts were not impartial. Then states sometimes makes very strenuous arguments with regards to disparaging language. But I think the jurisprudence is quite clear that merely because the applicant writes the communication in strong terms without specific disparaging reference to individuals in authority, it will not be deemed to be disparaging simply because you use strong words or you insist on certain language. That does not unnecessarily attack specific individuals per se. And then there's also the requirement that the communication must not be exclusively based on media report. But I suppose there is jurisprudence that if indeed media report is the only source of information that is available, then the commission would not refuse a complaint simply because the source of the information is media reports. And perhaps the most contentious issue in many communications, the exhaustion of domestic remedies. As you might be aware of, the only remedies that are required to be exhausted are judicial remedies. So you're not, for instance, required to exhaust administrative or other quasi judicial mechanisms that may be available. You're only required to exhaust domestic judicial remedies, which are available, effective, and are capable of redressing the kind of violations that you seek to have redressed. Then in the next few minutes, we would come to speak about the kind of exceptions that the Commission allows when it comes to the exhaustion of domestic remedies. I suppose the general idea in terms of the exhaustion of domestic remedies is to first give the states the opportunity to try to remedy the violations, because as a matter of expediency, if the state can resolve the complaint within its domestic mechanisms, then it serves no purpose to approach an international mechanism for redress that could have been provided for the domestic level. And then there is also the requirement that this must be submitted within a reasonable time after the exhaustion of domestic remedies, which in some cases have been interpreted to mean 6 months. But I think there is sufficient jurisprudence to suggest that the Commission does not follow this strict 6 months rule, and that depending on the circumstances of the case, a much longer period might be allowed if there's justification for the delay in not filing within that period. In terms of the exceptions to the exhaustion of domestic remedies, the well-known exceptions include the massive violations of human rights, which I perhaps mentioned earlier, that if there are a great number of victims involved, if there are massive violations of human rights, the assumption is that the state must be aware of these kinds of violations. It is not an obscure violation that happens to one individual in a small corner of the country, which the state can claim not to be aware of. If these are of such huge proportions, the only reason why these would continue to happen is either unwillingness or inability on the part of the state. So in circumstances where there are serious or massive violations, the Commission has allowed complainants to bypass domestic remedies because the state is deemed to be aware of this kind of violations and has simply not taken the necessary measures to remedy them. But also in instances where remedies are not available domestically. So for instance, if there is domestic legislation that ousts the jurisdiction of the national courts to entertain certain claims, then essentially you have no other avenue to complain in the domestic system, because those national courts do not have the capacity to entertain the claim that you seek to have adjudicated. But also in instances where the case has been pending for an unduly prolonged period of time, which I suppose would be dependent on the circumstances of this case. In the jurisprudence of the African court, it's said, for instance, that what amounts to undue prolongation would be dependent on the complexity of the case and the whole circumstances of the case. So that if it's a fairly simple case that one would expect state authorities to deal with quite expeditiously, then the time frame might be quite short. And within a short period, you could claim that it's been unduly prolonged. But if it's a complex case, for instance, you might have to give the state a bit more time to address these kinds of complaints, or if it's before the national courts, for the courts to address these kinds of complex legal issues before making a claim for undue prolongation before the African Commission. And then there is also the issue of, if you like, the sufficiency of the remedies themselves, so that if you go to a national court which does not have the power to grant you certain reliefs, if, for instance, if you are attacking a legislation, you think the legislation is in violation of human rights, but the national courts do not have the power to overturn legislation, and you are in a system where an individual cannot approach national courts to overturn legislation. That clearly is an avenue that will not provide you with results that are sufficient to remedy that kind of violation. But also, for instance, if that right is not guaranteed. So in many African countries where economic, social, and cultural rights are not guaranteed in national law or constitution, that kind of right would not enjoy remedy within the domestic sphere. And one could easily say that those kind of remedies are not available to the applicant, and therefore an exception can be made for the commission to allow the applicant to bypass those domestic remedies. So in terms of how the commission treats a decision on admissibility and the potential for review, the rules are now clear that if the state party does not make submissions on admissibility, the commission will proceed to make a decision by default based on the pleadings filed by the applicant before the commission, so that we do not have to wait for the state party continuously for inordinate amount of time. If the state is not cooperative, the commission would have to proceed to make a determination on admissibility without them. But you must also note that decisions on admissibility enjoy the same kind of confidentiality requirements in terms of Article 59 of the African Charter. So the parties are not allowed to disclose that decision publicly. Of course, if within an organization or a set of people who are working on the case, that will not be deemed to be disclosure to the public. But you cannot, for instance, post the admissibility decision on the website of the organization, or grant media interviews on specifically referencing the decision that the commission has made, because the commission can only make these decisions available after it's been considered by the Assembly of Head of States. But in instances where the commission declares a communication inadmissible, the applicant may apply for a review of that admissibility decision within 180 days if the applicant comes across new sets of facts that were not available to the applicant at the time that the submissions were made. And in this instance, the applicant must show that it was not negligent in not discovering this set of facts. So it is you cannot present facts that were in your knowledge at the point when you made the submissions, but which you did not disclose to the commission. These must be something new that you could not have, with diligent search, uncovered at the time that you made submissions before the commission. And immediately you become, when these facts come to your knowledge, you must file these new sets of facts before the commission, asking the commission to review its decision based on the facts that you've come into contact with. But you can only request for a review of an admissibility decision within 3 years of the date of transmission of the particular decision. So it is not, I mean, one would assume that after 3 years, you wouldn't be able to request for a review. I suppose what you would have to do is to file a new case that alleges similar violations, but including the new set of facts that would assist the commission to make a decision on admissibility. But if the commission declares the communication admissible, the state party can also apply for a review of that particular decision. And this must be done within 60 days of the decision being transmitted to the parties in this case. So, I mean, there is a case that I am personally aware of where a state party has, raised a further request for review after a review decision had been granted by the African Commission. I suppose there is no specific procedure that guides this kind of process, and once the review is finalized, that should be the conclusion of the proceedings as they concern admissibility, and then no further step might be acceptable from either side of the parties by the commission. The parties may also request the commission to adopt so-called investigative measures. If, for instance, the applicant is not in possession of certain facts that it assumes would be necessary in deciding the claim, it might request the commission to conduct its own investigative or adopt investigative measures, which may include on-site visits to actually interview potential victims, or to visit the site of the occurrence of the violations to ascertain for itself what the set of facts are. But the commission may also request documents or examine witnesses and experts who may be able to provide some form of information that is capable of assisting the commission to reach certain conclusive factual understandings that can assist the commission in reaching its decision. But whilst the case is pending, one of the things that an applicant can do, which the commission also has the power to grant on its own, is to make an application for provisional measures pending finalization. So if there are urgent matters that deserve attention, if for instance the health of the victims would deteriorate, or if evictions would render people homeless, if I mean, just giving examples, but if there are situations where harm would be caused that would be irreparable, then the applicant can make a request to the commission to grant provisional measures pending the finalization. And the grant of provisional measures in themselves does not serve as determinative of the kind of dispute that is between the parties, but it's just to preserve the status quo whilst the commission is determining or examining the complaints that has been submitted before it. Also important to mention perhaps is the fact that the commission does not need to be in session to consider provisional measures. The rules empower the chair of the commission in consultation with the working group on communications to make a decision on provisional measures. And Once this decision is made, it's transmitted to the state party, and within 15 days, the state party must report back to the commission indicating what specific measures it's taking to address the kind of provisional measures that is ordered by the commission. In some instances, the commission may actually hold oral hearings. A party may also request a hearing if the party is of the view that there are certain sets of facts or legal issues that could better be articulated through oral hearing. But if you're making a request for oral hearings, the rules require that you must make the request at least 90 days before the session of the commission. So you must notify the commission at least 3 months that you would want an oral hearing, and the request must indicate what kind of issues that you seek to ventilate through this oral hearing. But you must understand that this is completely at the discretion of the commission. So merely because a request is made does not mean that the commission would actually have an oral hearing. They may actually refuse to have an oral hearing if they are convinced that, based on the pleadings that is filed by the parties, they are capable of determining the issues, both legal and factual, on the papers alone. But if the commission decides to have a hearing, the hearing is private. It's not a public hearing. The only parties who are allowed to be present are the parties, the victims, the legal representatives, and the witnesses or experts as may be allowed by the commission. And in other instances, third parties like Amicus or interested parties who may be allowed by the commission to participate in such hearings. We must also note that hearings are deemed to enjoy the same kind of confidentiality that Article 59 of the African Charter requires. So if you attend a hearing, you are not allowed to publicly disclose what happened in the hearing or to discuss the hearing in the news media or on any other platform until the final decision of the commission has been considered by the Assembly of Head of States and the commission has published it. I will quickly talk about Amicus Intervention, since I just mentioned the potential for Amicus to be part of the hearing as third parties. The rules are now quite clear on the intervention by Amicus, who may be invited by the commission or who may request to make submissions before the commission. So the commission might make a public call or write individually to certain individuals or organizations requesting them to make submissions on certain cases. If the commission deems that such individual organization has expertise or experience on a certain issue and is capable of assisting the commission reach either factual or legal clarity on some of the issues, that kind of request might be made. But also if an entity or an individual deems itself capable of providing assistance to the commission in sort of elucidating some of the issues, you may make a request to the commission, which may or may not be granted. But when you make a request to the commission, you must indicate what kind of contribution that you would wish to make as part of the Amicus brief. And there's a requirement that whatever issues you're covering, you must not exceed 10 pages. So within 10 pages, you must indicate to the commission what it is that you wish to contribute to this kind of communication, and how that kind of that contribution enables the commission to better understand the issues and to reach certain outcomes. And if you make a request for Amicus submissions and it is granted, now the rules are clear that the commission will share the pleadings of the parties with you. I mean, I know previously, because I have made Amicus submissions before, and the way in which we have come into making Amicus submissions is that either of the parties would secretly whisper into your ears, oh, there's this case before the commission, and if you're interested, you can make a submission as amicus, and then you might get the pleadings from the party that mentioned the case to you. And now the rules are clear that you can request, or when you request to be an amicus and it's approved, the commission must give you the pleadings so that you're better able to make submissions to assist the commission to the kind of decision that it is capable of reaching. But once the request to submit an amicus brief is granted, you have 30 days within which to make the submissions. And amicus submissions enjoy the same kind of confidentiality rules. I do not agree with this kind of confidentiality when it comes to pleadings, but in terms of the rules, that is what any person who is making submissions, either as an applicant, respondent, or as an amicus, must deem that whatever submissions that they make is confidential and cannot be disclosed to the public. The commission may also allow the amicus to make oral submissions if there is a hearing, and if the commission deems that the amicus might be useful in elucidating its points orally. And there is an interesting requirement that the commission may publish the amicus brief on its website. But it's not clear whether this will be whilst the case is still pending, or this will be after the commission has made the decision and that decision has been considered by the assembly, because the rules indicate that even amicus briefs are confidential, but the commission has the power to publish the amicus brief on its website if it chooses to do so. But in addition to intervening as an amicus, now the rules also allows interested parties to intervene if the party will either benefit from or be adversely impacted by the outcome of the communication, so that you do not need to be an interested party. If you have a specific interest in the case, you can make a request to the commission that you want to intervene as an interested party, because the outcome of the communication would either confer certain benefits on you or would impact you negatively in some way. And the rules require that the application to intervene as a third party must be submitted before the consideration of the merits. So if you become aware of the case at any time before the consideration of the merits, you may intervene as an interested party, in which case you might become either a co-applicant or co-respondent, or in whatever designation that the state or the commission might give to the third party that is intervening as an interested party. But I suppose now the rules are quite clear that there are avenues for other people to become parties to the case if you have a specific interest that you need to protect. In terms of the decisions on merit, if the state party does not respond to the pleadings of the applicant on the merit, the same rules as they apply to the admissibility decision would apply, in that the commission will proceed to make a decision by default by looking at the pleadings that the applicant has submitted for the commission. There is now also a requirement that the commission must make a decision on the merits within 1 year from the time the communication becomes ripe for a decision on the merits. I'm not exactly sure what that phrase means, whether perhaps it's from when the pleadings are concluded, or from if the commission decides to have an oral hearing, from when that oral hearing is concluded. But there is a requirement that within 1 year, the commission must make a particular decision after it's become ripe for decision on the merits. And the decision on the merits also enjoy the same kind of confidentiality requirements as those of admissibility and all the subsidiary pleadings that might be filed, such as amicus or interested third parties. Yes. The commission is required to notify the applicants, the parties of its decision 30 days, within 30 days after the assembly has considered its activity report. And it is also required now to publish the decision within 30 days of notifying the parties. In many instances in the past, you would be aware that there's a decision that is made by the commission that has been notified to the parties, but you cannot find it anywhere online. Now there is a specific requirement that within 30 days of notifying the parties, that decision must be published by the commission. I suppose, as usual, this will be on the website of the commission. And this would also enhance access to the jurisprudence of the commission going forward. I suppose one of the innovations that the rules provide now is also the issue of reparations and cost. The rules make it clear now that the commission may defer the decision on reparations and cost into another time, as is the practice of the African Court, and request the parties to make submissions on reparations and cost. So even though the commission may make a decision on the merits, they might not decide to conclude on what kind of reparations or cost should be awarded to the parties. And based on the commission's own discretion, it might request the parties to make further submissions justifying, for instance, if an applicant is seeking compensation, they may be requested to justify why a certain kind of compensation should be awarded. And that a decision on the reparations and cost would be a subsequent decision that is perhaps not part of the merits per se. But the merits decisions may also be reviewed if either of the parties requests for a review of the decision. And similar to the review of admissibility decision, you must allege or submit new settlements that were not available at the time that the pleadings were filed. And the review application must also be made in the same manner, 180 days upon discovery of the new facts, and at any cost within 3 years of receiving a decision from the commission. There's also the rule that if a state party does not make submissions on the merits, then it is precluded from making a request for review, unless it can justify to the commission that there are certain circumstances that prevented it from making submissions on the merit, and the commission considers that it is in the interest of justice to consider the state party's request. I mean, it's perhaps unclear how the commission would be either strict or liberal to state parties when it comes to this kind of non-cooperation sometimes, which the commission faces from some state parties. But essentially, if the state does not respond, then the commission may deem that they have no objection to the commission reaching a decision simply based on the pleadings of the applicant, and they do not have a right on its own to make a request for review, even though the applicant has the right to make a request for review. In terms of the kind of remedies that the commission is allowed to grant parties, the rules make it clear that the commission may explore the process of friendly or amicable settlement, and this might be something that may be suggested by the commission on its own, or either party at any time may request that the case be settled amicably. And if the commission's request or the request of either of the parties is something that the other party agrees with, then the parties or their representatives are required to have a written agreement on what exactly the scope of the amicable settlement between the parties is. But there's a requirement that whatever agreement is reached between the applicant and the state must respect human and people's rights. It must indicate that the victims or the successors of the victims have agreed to the settlement, and it must include an undertaking by the parties that the settlement will be implemented. And when the Commission is satisfied that all these requirements are in place, it will adopt or endorse the agreement of the parties as its own decision. And that amicable settlement agreement is subject to the same kind of follow-up procedures as though the Commission had actually granted or had made a decision after considering the pleadings of both parties. Well, in instances where the decision is made by the Commission may make declaratory orders declaring certain violations have been committed, but also in certain instances requesting the state party to take specific actions to remedy the violation in compliance with the African Charter or other human rights instrument that is being violated here. But in some instances, the Commission may also order compensation or some other form of just satisfaction that it may deem capable of repairing the kind of harm that the victims have suffered, or that may be able to provide satisfaction to the successors of the victim if the victim is deceased. And within 180 days of the decision being reached, whether it is it's based on amicable settlement or it's a decision that is reached by the Commission after considering both the applicants and the respondent state's case, the respondent state has an obligation to report back within 180 days of the measure that is taken to implement the decision that was made by the Commission. And the rules now also indicate that the Commission may request national human rights institutions, such as your ombudspersons, your national human rights commissions, or public protectors, to provide information on implementation of decisions by a state party concerned, so that it's not only the executive that may be asked to make representations on implementation. NHRIs may also provide information to the Commission upon request on what exactly the state has done to implement the decisions of the Commission. And the rules also now requires that the Commission must report on the status of implementation at each ordinary session. And for researchers like myself, usually it's very difficult to find information on implementation. If you're not someone who has the time to go into a particular state to interview state parties and NGOs that litigated the case, there's literally no information that is available publicly on what exactly the state has done to implement the decisions of the Commission. And hopefully now that the rules require that the Commission must report at every ordinary session what is the status of implementation, and additionally include it in its activity reports. So each activity report should now ideally have a section on the status of implementation of decisions, which would inform both litigants, but also the general public, the specific measures that states are taking to implement the decisions of the Commission. Perhaps this will also make the work of the Commission more tangible when the African people can see that actually state parties do give some consideration and implement some of the decisions of the Commission, and this is a mechanism that we can use to hold state parties accountable. Well, similar to the old rules, there is still a provision that the Commission may facilitate access to legal aid if it's in the interest of justice to do so. So if you're an applicant or an NGO that does not have lawyers or legal representation that can prosecute a case on your behalf, you may make a request to the Commission to facilitate legal aid. The African Union does have a fund for legal aid that may be resorted to facilitate communications and other kinds of complaints mechanisms, both before the commission, the court, and the committee of experts on the rights of the child. So, I mean, that's briefly, that is the complaints mechanism as pertains before the commission in terms of the 2020 rules of procedure. But I'll quickly say a few words about the complementarity between the African Court and the commission in terms of what the rules now say about the commission referring cases to the court, and then we can open the floor for comments and questions. In terms of the old rules of procedure, the commission had a number of instances under which it could refer cases to the commission, and these included if it made provisional measures that were not complied with by the state, if it made decisions that were not complied with by the state, or if there were massive violations which has come to the knowledge of the commission, which the commission can refer to the state, to the African Court, I beg your pardon, and that the commission could refer a case to the court essentially at any stage. Now the rules are quite restrictive in terms of the circumstances under which the commission may request a case, refer a case to the African Court. And under the 2020 rules, the commission can only refer a case to the African Court before deciding on admissibility. So the commission cannot, for instance, proceed with a case and make a finding against a particular state, and then if the state refuses to implement the decision, then it approaches the African Court. Now they can only refer a case that is fresh, that has not received any kind of a formal decision beyond the seizure that is done as an administrative issue by the secretary. So before deciding on admissibility, the commission must decide whether or not it wants to refer this case to the African Court, which seems a bit restrictive, because I would have thought that the old rules were a bit more expansive and provided many opportunities for the commission to engage the court in that complementarity fashion. But we leave to see how the commission will interpret this rule, and whether the African Court itself, I'm told the African Court is adopting or making its own 2020 rules of procedure public on the 25th. So we wait to see whether the court is also only willing to accept communications referred to it by the commission only before, when it's a fresh case, without having made any form of determination on the matter. My understanding from my personal engagement with the registrar of the African Court is that interaction between the court and the commission resolved that, well, according to the court, the court is a judicial entity and cannot rubber stamp any decision of the commission. So the commission cannot make a determination even on provisional measures and hope that the court will implement it without re-examining it all over again. So the court does not deem itself bound by the decisions of the commission to the extent that it will simply implement them. And therefore, the agreement between the two institutions was that if the commission receives a complaint and it deems that it's of such a nature that requires a judicial attention, they should refer it to the court without even having to deal with it in any way, including admissibility. But of course, it strikes that the state party against which the commission may refer a case to the African Court must be a state that has ratified the court's protocol. And the rules also require that the commission must first seek consent of the applicant before deciding to refer the case to the African Court. And when the commission refers the case to the court, the commission becomes the complainant in this case, so that the original complainant before the commission sort of fizzles into the background, and the commission is the one that becomes responsible for essentially prosecuting the case, except the rules now allow the commission to appoint other persons or experts to represent the commission before the court. So there is a possibility that lawyers who work on pro bono, or even the representatives, lawyers for the applicant, may be able to represent the commission before the court, because the rules do not restrict those who can represent the commission to only the legal officers or the commissioners of the commission. So briefly, that's an overview of the new rules of procedure and how it impacts on the communications mandate of the African Commission. And I will welcome your comments, questions, and discussions subsequently. Dayo.
Thanks so much, Michael. I have posted the 3 questions that have come through for your sessions in the chat. Have a look, and maybe perhaps if you'd like to start answering some now, that would be great.
Thanks so much. I think I can post from your end, or you want me to read them out to you?
I am trying to navigate this chat.
Sure, read them out for him.
Okay, Michael, the first one says this is in relation to the consent of the victim to bring the communication. Does this consent have to be from the victim himself or herself, or can the consent be granted by the victim's family? Do you want to take that first?
Yes, no, I think I'll take that first. I think reasonably it will depend on the circumstances of the case. For instance, if the victim is a minor, it would be reasonable to expect that it will be a guardian or a patient, a parent, who would be the one that would grant the consent. Or if it's an individual who, in some countries, if a person has a certain kind of mental disability, that individual is not deemed to have legal capacity to, make certain declarations or sign certain documents. But also, in the instance of where I indicated that the person might actually be in custody without access to family or counsel, it might be reasonable for, if you like, family or some other person who is close to the victim to be the one who grants consent. I can also foresee the instance where the person is in a coma, for instance. If the individual is in a medically induced coma and it's incapable of actually physically granting consent on their own, those are reasonable instances where other individuals such as family, or spouse, or guardians, or close relatives will be able to provide consent for the victim. But even in instances where there's no such family to consent, like I indicated, the rules allow the applicant, which in many instances would be a civil society organization, to write a justification why it is not possible to get consent. So the consent is not absolute. It's not something that cannot be dispensed with. It may be dispensed with if there is a reasonable excuse not to do so.
Thanks, Michael. The second one is relating to the submission sequence of pleadings. It says, is it the case that filings on admissibility and merits must be made within 60 days of receiving notice that the Secretariat is seized of the case? Or does this mean applicants should hold off submitting detailed submissions until hearing from the Secretariat on seizure?
I would, if I was the one who was filing the case, I would file everything. I would file the submissions on admissibility, on merit, and on seizure at the same time, because I really honestly, before I decide to file a case, I would have had the whole set of pleadings together. So that but in terms of the rules, you're only required, it does not preclude you from actually preemptively filing these things when you do send in your your complaint for seizure, but they're only required to make pleadings on admissibility and merits within 60 days of being notified of the seizure decision by the secretary. But I would think that there's nothing that stops you from filing everything together. If you do have your case together and if you're prepared to make submissions from the beginning, I would think that to save time, it's perhaps easier to prepare everything, file it, and when the secretary notifies you that it's been seized of the case, you can notify them that you rely on the arguments on admissibility and merits that has already been submitted with the seizure pleading. So it is not really an either or. It's just what is required, but you are not prevented from, preemptively filing all of them together, if that also works for you.
Thank you so much. The next question is, given that both the African Charter and the Rules of Procedure contain no specific provisions on local standard, what criteria does the Commission use to assess local standard? Also, what's the situation when legal representatives representing the victim in the respondent state got arrested before the admissibility stage? In this kind of cases, how will the Commission proceed with the communication?
Yeah, I suppose the Commission has been quite liberal when it comes to standing, and we've all been aware that the Commission adopts, which utilizes this notion of actual popularis, that you can bring a communication in the public interest, and that the applicants themselves need not be a victim. I suppose the slight change that has happened now with the coming force of the 2020 rules is the requirement that if it is possible to provide the consent of the victims, then perhaps you need to seek the consent, and that they may deem you not to have standing if the victim is someone who is readily available and whose consent you could have sought and which you didn't. But otherwise, I think the standing rules are quite liberal and not very restrictive. I cannot foresee of an instance where the Commission would outright reject a standing of a particular individual or civil society organization, unless no justification at all is provided for why consent is not sought, or it will be essentially deciding to get thrown out. You would have to decide that you want to be thrown out on standing for you to get thrown out before the African Commission. Otherwise, I think it's quite easy to navigate around the rules. If you can't find the victims, or if they are not available to give consent, you just have to write a justification for being allowed to bypass that kind of requirement. And I think the Commission has been quite liberal in many instances when it's granted standing to parties before it. In terms of if the legal representation is arrested before the admissibility stage, like I mentioned, the Commission does have the ability to facilitate legal aid. So if your legal representation is arrested because of certain actions within the state, I think the right thing to do is to write to the Secretary and indicate what exactly is the circumstances right now that your legal representation has been arrested, and that you would need legal aid to be facilitated by the African Commission. And I would suppose that that would be a good reason for the Commission to make an application to the fund. The African Union does have a fund for its human rights bodies to provide legal aid to persons who do need it. And I think in many instances, the African Court has utilized this kind of fund to especially provide legal aid to prisoners who file complaints before the court who do not have legal representation per se. So I would suggest that if your counsel is arrested before admissibility, just write to the Secretary of the Commission and let them know that you have an urgent need to be provided with legal aid, and I am sure that the Commission will facilitate that kind of legal aid.
Thank you. Question number 4 says, have the new rules affected the timing of merit submissions for cases that were already pending prior to the adoption of these new rules?
That is not a really straightforward question to answer. I mean, one could say that if you already had cases pending before the Commission, that the rules as they are now cannot apply retroactively. But you could also say that from now that the rules are enforced, those are the rules that the Commission apply, and therefore you cannot go back and apply the old rules. I would think that I would apply the new rules and let the Commission tell me that they are still sticking to the old rules in terms of communications that were already pending before the rules came into effect. But I would think that if the old rules are no longer enforced, then they surely cannot be used as the basis for the timelines as regards the Commission's own processes and procedures. But I think if you're not really certain of what to do, you can always reach out to the Secretariat for them to provide their own understanding of what it is that would happen to all the cases that were pending before these rules came into effect in July. But in my mind, they would still apply the new rules, even to cases that were already pending, especially when it comes to timelines.
Thanks, Michael. The 5th and last question we have from is, what security exists in the new rules against interference through local buying and compromises by commissioners who are citizens of state members who are selected as respondents?
Well, I mean, the rules are clear that a commissioner cannot sit on a case against a state of which they are a citizen. So if you submit a case against a particular state and there is a commissioner who is from that particular state, that commissioner is precluded from being a part of the panel that will discuss or elaborate, what do you call it, take a decision on that case. But it's not only with regards to the commissioner being a citizen of that particular state. If there are any other circumstances that could potentially preclude impartiality. So if the commissioner, for instance, was a political or administrative figurehead in a particular state, or was counsel in some capacity for a particular state in relating to this particular matter, if there is any kind of issue that one could potentially say this would preclude that commissioner from being impartial and independent, it's one of the objections that you can raise if you know that commissioner has previous interest in the case or has previous knowledge of the case, and that their impartiality might be affected. But definitely, if that commissioner comes from a state party that is respondent to a particular complaint, they must recuse themselves, and the complaint will be heard without them. It applies, I think, to all the three human rights institutions, both the Commission and the Court and the Children's Committee as well.
Thank you. We have another question. Thank you for this wonderful overview, Michael. Regarding the new rule on deferring the decision of costs and reparations, do you read this rule as allowing the applicant to request that written submissions of costs be made, or that it may only be at the invitation of the Commission?
That the applicant must make written submissions on reparations.
Can the applicant make this request on their own initiative or when submitting the complaint, or they can only submit at the invitation of the Commission?
Well, I would think that a request may be made by, if you like, the applicant as well, but I don't really know why it would be in the interest of the applicants to want to go an extra, procedural level, which could potentially waste more time. I mean, unless the situation is that you did not have the full set of facts or documentation that supports certain request for reparation at your disposal before you file the case. I mean, insisting that you want to make, submissions on reparations subsequently only would cause further delay. But I would file everything together and let the commission decide whether or not there is necessity to actually have an additional, if you like, a means of reassessing reparations and cost. But I mean, in terms of Rule 121, is the commission that may decide to defer the consideration of reparations and cost. So it seems that the discretion is with the commission, but I would not assume that merely because the discretion is with the commission would mean that then the parties are precluded from making a request. So it would simply mean that even if you make a request, that will completely be dependent on the commission to either accept or deny that request. But the commission has that leeway to decide that we don't have sufficient sets of if you like, information to make determination on a particular reparation or cost request, and that we will defer that for another time when the parties have been requested to make submissions on these. But I would assume that the parties can still request if that is something that would assist in making a proper determination of what the reparations and costs actually are.
Thank you. So, do the new rules envision electronic filing? And is there a software program being developed for such method if projected?
Well, I think we have always filed cases via email. So I think e-filing has always existed, even before the existence of the new rules. Because for most of the cases that I have been involved in, I have simply sent an email to the secretariat, and they would usually respond back with an email. So I think, also because the rules now require that if one of the particulars that you must provide as an applicant is your email, your telephone number, and other forms of communication. So e-filing, I'm not sure whether there's a specific software for receiving complaints, but I think email communications are usually acceptable to the commission. I don't know what your own experience is, Oludayo, but I find that the commission usually accepts filings by email, and they have not objected to receiving filings by email.
In our own case, we file both. Send an email, and because our office is just a 2-minute drive from the commission, we also deposit a hard copy. And in fact, a lot of our friends from across the continent who want to file send us a copy of their pleadings, so that after they have sent the email of the pleadings to the commission, we also help assist them in depositing the hard copy. And so the commission, both the electronic and the hard copy delivered to them. Okay.
I've never had to file an actual physical copy before. I've always utilized emails, and it seems pretty fine.
Thank you so much for this wonderful presentation and for dealing with the questions very, very well. Thank you. You've been excellent. I think I have the agreement of everybody participating that this has been really helpful, especially with regards to explaining the contents of the new rules and how they impact the communications procedure. But before we put an end to this workshop, I just briefly wanted to
tell all participants, this workshop has been organized by the Litigants Group, which is an advocacy network of about 65 to 70 civil society organizations and individuals interested in strengthening the communications mandates of the African Commission. The Litigants Group is having a meeting next week, Monday, the same time as this workshop. And it will be great if we have as many participants who are also interested in the Commission's communications mandate join us for that meeting. In addition to that, the group organizes legal aid for individuals and NGOs, civil society organizations that want to file communications before the African Commission, but have limited expertise. And so if you would reach out to myself at IHRDA, Michael at the Center for Human Rights, or Sibongile Ndashe at the Initiative for Strategic Litigation in Africa, we'll be able to determine which kind of assistance you need and how best to provide that assistance. I think what we'll do, we'll share information after this meeting of how to join us for the Litigants Group meeting of next week. And we look forward to seeing as many of you as possible in that meeting. If there are no new questions and no new contributions, I guess that brings us to the end of this workshop. And I thank all of you for joining us. We've had about 23 attendees. Thank you so much, all of you, for taking the time to join us. And I wish you a wonderful week. Thank you.
Have a good week, Dayo.
Thanks, Michael.
And Tiffany and everyone else.
Yeah.
Thanks, everyone. And I posted the registration link for the Litigants Group meeting next week. I posted that in the chat.
Very well.
Thank you, Tiffany. All right, see you all next week then.
See you.